and it is designed to respond quickly to emerging industry and consumer issues, and it should also provide for a process that is independent in its oversight and enforcement of the compliance of code subscribers. Codes, in terms of where they fit into the financial landscape or financial services landscape, is at the top of this pyramid that you can now see. At the base of the pyramid, you have your legal obligations. So this is the law, the regulatory guidance, the court decisions, and they describe the minimum standards and the expected conduct that the financial services providers should be delivering to consumers. You move then through the company arrangements with that customer, which is usually in some form of a contract or perhaps even supplemented by a customer charter. And then you have the code of practice at the very top, which is really about good industry practice, and not just good industry practice, but about raising standards of practice for that particular industry. Oh, sorry, going the wrong way. Now, in terms of why would an industry bother to even commit to a code? Well, it's about building consumer confidence and promoting trust. It's about building those relationships between the members of that particular industry and their customers. It's about providing a strong framework for improved relations between the members of that code of practice, customers, and certainly in the general insurance space, third parties as well. It's a means of providing continuous improvement within the industry, and it's also a means of, I guess, looking at or ways of improving the way the products are designed, the way that procedures are built, to assist also in analysing what went wrong and using the code standards as benchmarks to measure against. And ultimately, you want to see a reduction in complaints from consumers, and you want to see improvements in the way those complaints are held. Now, the next slide, I'll just quickly take you through it and just show you how FOS fits into the code landscape. So the code team is part of FOS, but we operate within that organisation through, we're supported in what we do through the funding that is provided by the members to the various codes of practice that FOS administers, and we must administer 4 codes of practice: banking, general insurance, customer-owned banking, and insurance broking. In all 4 codes of practice, we have independent committees. In all 4 codes of practice, there are arrangements in place between the members of the code and that committee, and usually the association as well, that binds the members of that code to the actual terms of the code itself. And we're funded to do what we do by fees that industry members pay in supporting that particular code of practice. So in terms of the General Insurance Code of Practice, well, it became operational on 1 July of this year. So it was released a year ago, and the industry had 12 months to transition to the new standards. So the new code is now in force. There are about 157 subscribers, and I say about because it does fluctuate a little bit. We have at the moment 49 general insurers and 108 Lloyd's Australia Limited cover holders and claims administrators. In terms of the general insurers that you're likely to deal with, they will be members of this code of practice. The code itself now, as a revised document, provides for a transparent and independent governance framework which supports effective monitoring and enforcement of compliance, and this revised version is written in a plain English style. So the objectives of the code are to commit subscribers to high standards of service. It's designed to promote better and more informed relations between the subscribers and third parties and the customers. Again, talking about promotion of trust and confidence in the general insurance industry and providing mechanisms for the resolution of complaints and disputes between subscribers, customers and third parties. And it's about continuous improvement. I will move on actually onto what the focus of the 24 GI code is, and you do have this presentation, so hopefully you won't miss out on anything if I do push through a little bit.
So can I just interrupt?
Sure.
The code itself is on the Insurance Council of Australia website. Is it on the FOS?
It's on the, so it's on, the address for the Code of Practice is www.codeofpractice.com.au, and that's where you'll find the code. You can also get a link through the Insurance Council's website and from the FOS website as well. The 2014 code, or the revised version of the code that's now operational, focuses on retail insurance products. So if you're dealing with clients who have issues with their insurers relating to motor, home, sickness and accident, consumer credit, travel, personal and domestic property, then all the standards in the code apply to the services that they receive from their general insurers, provided, of course, that that insurer is a member of the code. And as I said, it's more than likely that they will be a member of the code. The key standards that the code covers relate to buying insurance, the standards that apply to the employees and authorised representatives of co-subscribers. Now, in terms of employees as well, it's wider than just the employee of the insurer. So if the insurer uses a related entity to carry out services on its behalf, then they're treated as though they were employees under the code. An authorised representative, of course, is not an employee of the insurer, but there's a contractual arrangement in place. They've been appointed to act as an authorised representative for the code subscriber. Section 6 deals with the standards that apply to service suppliers. Section 7 sets out fairly lengthy and detailed benchmarks around claims handling. Section 8 has been revised and enhanced, and it deals with the standards that apply to consumers that are in financial difficulty. We'll talk about that a little bit more in a moment. Section 9 deals with the standards that relate to claims arising from catastrophes. Section 10 deals with complaints and disputes. And the other key section is Section 14, which is about access to information, the personal information that your clients might provide to insurers and their agents.
Just before we leave that one, so for you Queenslanders, when that earthquake happens on land, you need to be aware that there are special rules that actually apply for that sort of event over and above whatever's in the legislation or elsewhere in the code.
And that's a good point, because what the standard what it provides for is that if there is a claim that relates to property, and that's really anything to do with not just a house, but also the contents, other property items that may have been damaged or lost as a result of the event, then if the claim is settled within a month of that event occurring, your clients actually have up to 12 months to go back to the code subscriber and ask them to review the basis of the claim settlement. If they think, for example, something was missed when the claim was settled, or if they feel that it doesn't accurately reflect the value of the property. So they can go back at any time up to 12 months and ask the insurer to review the settlement again. Now, they should be telling consumers that as well when they settle the claim. So provided the claim was settled within a month of the event happening, then they should be telling your clients they have up to 12 months to go back to the insurer to review settlement if they've got any concerns about the comprehensiveness or accuracy of that settlement. Now, financial hardship standards. The code has actually, for the first time, defined what financial hardship means, and it's simply put as difficulty meeting financial obligations to a code subscriber. It means that if a party is in financial hardship, they're entitled to ask the code subscriber to assess their position and ask for assistance in relation to that financial hardship. Now, what the code has also done is it's expanded the scope of the financial hardship standard so that it's always applied to people who are considered in debt to the insurer, so someone who has caused damage to the co-subscriber's customer. Generally, we see it in the situation of a motor vehicle accident situation. But what the code has now also done is it also applies to insureds and third-party beneficiaries of the policies held with those co-subscribers. So it means that if you're dealing with or representing a client who might have lodged a claim and must pay a fairly large excess but are in financial difficulty, then they can actually apply for financial hardship assistance under the provisions of the code. So when a co-subscriber is informed by you or by an individual that they're in financial hardship and they want assistance, they must provide an application form for financial hardship assistance. They must provide the consumer with the contact details for the National Financial Counselling Hotline. They can ask for information, of course, to assess the financial hardship assistance application, but it must be reasonable and it's got to be relevant to the basis of the application for assistance. They're also required to tell the individual what the decision or the outcome of that financial hardship application is, and they must also provide them with information about their right to access the co-subscriber's internal complaints process if the hardship assistance is refused. When the hardship application is being considered by a co-subscriber, any recovery action that's on foot must be put on hold while that is happening.
So can I just, and we didn't mention it earlier, this applies as much to a debt collector or a lawyer as it does to the insurer, and it doesn't matter whether we're talking before or after judgment. This actually simply applies to the process of collection.
So if at the conclusion of the application process for assistance, the subscriber agrees that assistance is warranted, then they must start discussing and hopefully come to some sort of arrangement about a repayment plan if that's appropriate in the circumstances. So some of the things that they consider doing is extending the due date for payment of a debt, paying in instalments, paying reduced lump sum amounts, postponing one or more instalment payments, and a combination of any of that. Any agreement about a debt repayment plan must be confirmed in writing. Now, at the same time, if you're of the view that the debt ought to be waived, you can actually ask the co-subscriber to consider waiver of the debt on behalf of your client. Now, they're not required to come to that conclusion, of course, but it's something that you can ask them to consider. And if they do come to the view at the end of the day that the debt should be waived, that should also be confirmed in writing. And again, if there's no agreement about waiver of the debt, or perhaps you're seeking a discharge or a release from the obligation, and there's no agreement about that, then again, the co-subscriber must inform you of the availability of the complaint handling process for your client so that that decision is reviewed through its internal complaints handling process.
Just before we leave that one, it's worth remembering when you get a letter on behalf seeking payment from your client for a motor vehicle accident, it either comes from collections, a debt collector or a lawyer, and they're all paid to collect, not to waive. So you shouldn't be entirely surprised if this part of the operation doesn't want to waive the debt. It is why the next part, that is if you don't reach agreement, you can go on to the dispute resolution, is important, because dispute resolution are kind of paid to be the warm and fuzzy sort of people who will consider much more, and they're not paid purely on the basis of collection. So just try to remember that when you send the first letter, you are sending it to someone who will not necessarily be sympathetic.
So some other things that the code provides for is that now, especially now from 1 July, if the code subscriber is using a collection agent, as Denis highlighted, that includes a lawyer that's acting on behalf of the insurer to seek recovery. When they first contact your client, or when they contact you, they should be telling you that they are acting on behalf of an insurer. If that insurer is a code subscriber, they must name who that is in any correspondence with you about the alleged debt. So they can't simply hide behind the name of the person that suffered the loss or the damage. They must identify who the insurer is that sits behind that. And in addition to that, they must clearly specify the nature of the claim. So what is the nature of the demand that they're making? Now, the subscribers, as well as their agents, and that again includes legal firms, must comply with the ACCC and ASIC debt collection guidelines, and I'm assuming that you're all familiar with that. The code makes it, if the code subscriber or the agents do not comply with any aspect of the debt collection guidelines, they will be in breach of the code. So that's something to keep in mind. So if, just very, very briefly, the guidelines provide some very clear guidance to collection agents and creditors about how they go about seeking recovery, about their conduct, about contact with consumers and the like.
Next time you've got insomnia and you're looking for something to do,
have a look.
Just have a look. There are actually some quite interesting things in there. So, yeah, it's a cure for insomnia, but have a look.
Now, the code subscriber must provide information about its complaints process if it cannot come to an agreement with you on the amount of the debt owing now for purposes of a declaration of bankruptcy. That's a new obligation under the code. So, again, if there's an intention to pursue bankruptcy, then the code subscriber must make the complaints handling process available if there's no agreement on the amount owing for the purposes of bankruptcy.
And for those who don't know, if you want to put a motor vehicle accident on a debt on bankruptcy, I've forgotten the technical term now, it has to be a liquidated debt to put in to state in writing what the specific amount of the debt is, and the bankruptcy jurisdiction has said it will accept that. So under the code, you're now able to ask either the insurer or their representative to put in writing how much the debt is for the purposes of bankruptcy.
So there's a bit about the collection guidelines. I won't spend a lot of time on that because I know I'm conscious of time and Denis needs to start his presentation as well. But I think it's Denis's point about familiarising yourself with the guideline is very important because it really does define the conduct of creditors and collectors when they're dealing with your clients. Okay, so I'll spend just a very short few minutes just quickly outlining for you as well some of the key provisions of Section 7 of the Code, which applies to claims. Now, I'm not really sure of the nature of the work you deal with, but if you do represent clients who have claims with an insurer that is a code subscriber, then Section 7 sets out some very clear and detailed obligations that insurers must meet in the processing of the claim. At a high level, if you're talking about a retail insurance claim, such as with a motor vehicle policy or a home policy, claims that of that nature, you should expect to have a decision on the claim within 4 months, for example. Another important point is that when a person lodges or seeks to lodge a claim with their insurer, but they're not sure whether or not the claim is likely to be accepted, the insurer must not deter them from lodging the claim. They're entitled to lodge their claim and entitled to go through the claims processing process and allow for a decision to be made without it being made upfront or being discouraged from lodging a claim because it might fall outside the scope of the policy.
Or to be even more brutal about it, they're not allowed to say you can lodge it, but that's going to fail.
That's exactly right. They cannot say that. They must say, in fact, that you're entitled to lodge the claim and we will process it in accordance with our usual processes. So the claims handling standards now apply to third-party beneficiaries as well as policies. That wasn't the situation prior to 1 July. There are standards that set out the framework for conduct of employees and service suppliers. Sorry, let me just go back one more. Overall, claims handling must be conducted honestly, fairly, transparently, and in a timely manner. There are specific timeframes set out for various steps in the during the claims handling process. As I said before, within 4 months, you should expect to have a claim decision within 4 months, unless exceptional circumstances apply to the claim. Now, a couple of things come to mind immediately. Extraordinary catastrophe, so extraordinary like the 2010-2011 floods in Queensland. They're two of the key reasons why the 4-month time frame might not apply. But if that's the case, they have up to 12 months to make a decision. But that doesn't mean, though, that it's reasonable for them to take that length of time, and that would be something we would look at if there was a concern about how long it was taking a co-subscriber to make a decision on the claim. If they're unable to meet specific timeframes under the code, and that applies also to a decision on the claim, then they should be, again, notifying consumers or your clients of the delay in that decision, that they've got a right to raise a complaint about that through the internal complaints process. One of the most important things about the standards for claims handling that I'd like you to keep in mind is around the denial of a claim. When a code subscriber denies a claim, they must put that denial in writing. They must provide reasons. They must tell your client that they have a right to ask for copies of information that they've relied on in coming to that decision, and that includes the reports of experts and service suppliers. And of course, they might argue, for example, that something can't be released because it's privileged in some way or the like, but if they do that, they have to give you reasons, and they again have to tell you that they have a complaint process that's available to review that decision. And of course, that letter notifying of a claim denial must also tell your client that they've got a right to access the complaints process if they're unhappy with the decision to decline the claim. The last thing I'll say before Denis starts his presentation is that another key thing to keep in mind is that your client is entitled to raise a complaint about any aspect of the claim. So if it's about delay in decision making, if it's about the way a service supplier is dealing with them, if it's about the fact that they have no idea what's happening, they can raise a complaint about anything at all relating to a claim. They have an entitlement to do that, and the code makes a clear acknowledgement of that right. All right, I think I'll probably stop there so that, Denis, you can have a chat and...
Why don't you just turn that sure. I'm just get mine up. So we'll just get my presentation up, but I'm going to speak briefly, very briefly, about some key points, and then I'm going to move to one of the letters that you were sent.
Yeah.
So I'll just start. This is in the materials you were sent, and you don't need to be able to watch this while we'll see if we can get it up.
So where's your stuff?
So,
do you know what?
So I'll just start by saying the main purpose of the code and the letters that you've received are to move the dispute resolution for legal centres and other community workers, move that from a dispute around liability and quantum to a dispute about capacity to pay. I won't go through the reasons now, but the vast majority of people who are uninsured, who turn up at our legal centres, about 85 and 90% are probably liable. Whether they're liable for the full amount might be disputed. But if our clients are judgment-proof in the sense that they have nothing more than Centrelink and they're renting, then it's fair to say that fighting liability in those circumstances doesn't actually make a lot of sense. Just bear with me a moment. Secondly, it's quite amusing when people say, oh, they're judgment-proof, but the accident couldn't have cost that much, so they want to dispute quantum. Now, if the quantum is between, let's say, 8 and 12,000, but our client hasn't got any money at all, we're not going to offer 12,000, we're not going to offer 8,000, we're not going to offer 5,000. If we made an offer, it'd probably be 10 cents in the dollar. So you don't need to worry about quantum if you're actually only ever going to offer 10% of what it is, and in likelihood for that client, you're going to seek a waiver. So I think everyone who's listening would already know that we've moved really away from liability and quantum, and we've moved to talking about the capacity to pay. Now, the materials, you can have a look, just again give you the background about the background legislation, the Asset Corporations Act and so on. I'll go to the next slide. So in the Corporations Act, all financial services provided, that's all insurers, have under Section 912A, have a mandatory obligation to have a dispute resolution system which includes an internal dispute resolution, IDR, and they have to be a member of an external dispute resolution, and in the case of insurers, that's always FOS. It's worth saying that disputes around breaches of the code go to the Code Compliance Committee, not to the FOS General Insurance Division. The next thing I want to say is it's important for our clients to recognise that compliance with the code is really important. And even if you get your client out of the debt or you resolve their problem, if there are breaches, making complaints to the code compliance team is really important, because it is the only way to get the insurers and their agents, including their lawyers, to comply with their obligations. Next one. Keep going. So I just want to again refer to a couple of key clauses. If you can't reach an agreement, you ask for a waiver or you put a small payment or an instalment payment, you can refer the matter to internal dispute resolution. Now, you obviously can't do that if you don't know the name of the insurer. And there have been a number of lawyers, more than debt collectors, who have been unwilling to divulge the name of their client. So one of the reasons that you need the insurer's identity is to know how to get to internal dispute resolution. Once you have that identity, you can actually ring FOS and ask how to get to IDR, or you can look it up on the website and you'll be able to find it. Putting recovery action on hold can be important because it may be a way of avoiding your client ending up with a judgment on their credit reference. The financial hardship, now we've always been seeking waivers, but it's actually specified in the code, which is a huge improvement, and I think Rose's presentation gave you the specific section. The need to confirm outcomes in writing. In the past, sometimes there's been an agreement not to pursue it, but they wouldn't necessarily put it in writing. Now, I should add, one really significant change in the last couple of years is that in addition to motor vehicle accidents, legal centres are seeing more clients who are tenants who are being sued for losses under landlord policies. The code applies as much to a debt around the land, including a dispute about liability. The code applies to a debt around a landlord policy as much as it does around a motor vehicle accident.
Can I just make one point about that as well? If you're acting for a client who is saying, yes, I am liable for what happened, but I dispute quantum, you've actually got a right to access the complaints handling process on that issue as well. So I just wanted to emphasise that point.
and we've certainly got some at Western Community Legal. Now, the agents and solicitors have to identify the insurer as their client. I've actually had some who didn't want to identify it but didn't realise that their reference number had the acronym for the insurer, but not everybody recognises those acronyms. Any lawyer who is not identifying their client, and there were some quite large and supposedly reputable insurers who were included in this, that is a really good instance where a complaint to the code compliance team is important. And again, refer to those debt collection guidelines. So we'll move on from there. Now we've sent out the letters, and I said there are 3. There's actually 5. So there's a letter. You've got letters which talk about instalment or waiver. As I said, those letters generally go to the collections department or to a lawyer involved in collection. They may not want to discuss that, which is why you may need the letter that goes to the internal dispute resolution. If you haven't ever tried that, I can tell you that they are usually sensible and sympathetic, something you won't always get from the collection side of a business or from the lawyer. And we also give you an example of a letter to the Code Governance Committee.
That's right.
Committee for breaches of the code. And I'm actually going to look at one of those letters now. So many of you will see, is that the end? No, we'll skip that. We'll go to, keep going, we'll go out.
You want to go out?
Yeah. So I'm going to look at 2 letters. The first is one that I would hope nearly all of you have probably seen, which is a standard letter of waiver. Just go out of that or?
Where did the letters go again? I'll get it again.
All right. So there are 2 letters that we're going to refer to. One is the standard form letter that many of you are currently using. And that is where your client is judgment proof in the traditional sense of the word.
Oh.
So I want to come back to...
Yeah, that's the code presentation still there. Okay. Do you want me to open that for you?
Yes, can you open
Yeah.
it? So the first letter is the one that I think has been around for about 5 years, and many of you will have seen it. Now, this letter is for the client who is renting, by and large, who is on Centrelink, who doesn't have significant assets. I'm going to assume that virtually all legal centres, legal aid, financial counsels are using that letter, and I don't really want to spend too much time on that other than to say my experience, and I do a lot of these, so my experience might be a bit different, but my experience is that the vast majority of insurers will respond fairly well to that letter without a great deal more than you're offering some basic proof that that's the circumstance. But the letter that I really want to refer to, can we get out of that one and into the other one, is the one that I've called the working poor. Because when we created this process, it was never our view that the only people... Is
that the one? Waiver working poor?
Yes, that's what
it
says.
Yes.
Okay, so a lot of our clients might not be on Centrelink. They might be a newly arrived client who is working in a factory or a meatworks. They're paying rent. It's a subsistence living, and we've actually had some cases at Western where either the insurer was willing or their representative was actually still wanting to look at a 10-year agreement, that is, $40 a month for close to 10 years, on the assumption that they would get every payment for 10 years. Now, we all know that doesn't happen. If they got half the payments, and I reckon getting half over that period would be a remarkably good effort, the 10 years becomes 20 years. We also had another one where there was a suggestion that our client would go and borrow the money, and we said, where will you borrow it from? And he said, oh, well, I'll go to a bank. my comment was to the lawyer, yes, and he'll come back 3 months after that and say he now has a debt to a bank that he can't pay. There was also a suggestion that he might borrow it from his community or from his family. We need to discourage those sort of things. So if you have a look at, I want to go through this letter a little carefully. So what this letter says is, in the third paragraph, as you may be aware, our centre assists many clients who are judgment-proof, whose sole source of income is from Centrelink, which is protected. Now, this is a Victorian letter. You may have to amend it for interstate. Who owns only normal household property, doesn't own any assets. Our client in this case is not typical judgment-proof, as he or she is working, earning an income from paid employment. Their income is barely sufficient to cover his/her normal living expenses. Your client has a number of options, the most obvious being an instalment order or an application for attachment of earnings. We submit that either of these options will end up being unsatisfactory for both our client and yours. We then go through the argument about saying, well, if you get an instalment order that lasts for 10 years, it doesn't make a lot of sense. So we say, we do not believe that it's in the interest of either party to establish a long-term instalment plan. The costs to your client of administering an instalment plan would arguably outweigh the value of the repayment. With regard to a garnishee order, we would stress that whilst our client is working, they're working for a private company, not the public service sector, working in a position that requires minimal skill and is easily replaceable, has no job security. And I think it's a common experience that low-income people who are working and get attachment of earnings get the sack soon after, because the employer doesn't want the paperwork. We point out that obtaining judgment or initiating legal action will pose significant costs which may never be recovered. And you know, they'll often say, well, we'll get judgment, and we say, yes, well, that's fine, but how will that help? In addition, our client has significant social problems, and the vast majority of our clients do, and these are likely to have a serious long-term effect on their financial position. Briefly set out the circumstances. Now, in here I say, do not provide or offer to provide supporting evidence at this stage. It's really important that we don't provide very complex personal medical reports for something as simple as a debt. You may want to say we can provide you with information about, you know, the treating doctor or the treating psychiatrist, but by and large, there are privacy issues here, and the more senior people in an insurance industry or a debt collector will tell you that they don't want that sort of information because they can't control what happens to it. So we say we submit that it's in the interest of the insurer to minimise the expenses and losses associated with the debt. We refer to the General Insurance Code and note that our client falls within clauses 8.6 and 8.8, which deal with financial hardship. Now, I mentioned two cases at the start of this. One where there was a request effectively for a 10-year plan. We wrote back and said, don't think that's a good idea. We used this letter. We have since had a response saying, we agree, we'll agree to waive. And the one where there was a suggestion for a loan, they had discussed that loan. We pointed out that no bank was going to give it. And it was more than a payday lender would want to give, I think. We also pointed out that it wasn't appropriate to go asking for family, and that in any event, we thought the general poverty of the client would preclude even his family from helping. The letter in both instances was successful. So I think we now need to move from looking at the really obviously judgment-proof, Centrelink renters, to people who are, in my view, still judgment-proof, but they may be working part-time, they may be working full-time but in insecure employment, they may be casual and so on. My view is that if we write these letters and you do a good job of the advocacy, there's every prospect that you'll get what you want. I still think the evidence is pretty obvious that the lawyers who act in debt collection can't respond very well to this at all. But just remember that even once a lawyer has sent this, if they reject your request, you're still entitled to go back to IDR. Now, I think that's probably enough. James, if people have questions for a few minutes, we're happy to take them.
Terrific. Thanks, Dennis, and thanks, Rose. Incredibly practical for information for people working in community legal centres. Folks out there, a reminder that there's a couple of ways that you can ask questions. You can either type a question into the questions box, or you can raise your hand. Dennis, you did make the point, I might kick off with a question of my own. You did make the point in your discussion that generally your clients are liable for that. I'm just interested in the letter, kind of from the outset, accepting liability, kind of the strategy behind that.
So the first thing the first thing I'll say about that is I've often asked lawyers in legal centres if they think their client was not liable, have they ever issued a counterclaim in the magistrate's court, and I've virtually never found anyone who's done it. Now, remember that if your client's insured and makes a claim, they'll only come to you if it's not back. If your client's uninsured and they're in the right, so if someone runs up their bum, insurers pay around 95 to 98% of claims. So in most circumstances, if your client's in the right, they will pay. It's really only going to be in marginal cases or cases where, for instance, the insurance claim might be knocked back because, for instance, the insured was drunk or there is a problem with the insurers, the insured's claims. Obviously, the letter is based on you making sure that, for instance, if your client says they were sitting at the light and someone ran up their bum, then you're not going to write a letter saying we agree we're liable. One of the things that I do encourage some of our lawyers to do is to say there may be an aspect of either liability or quantum we disagree with, but there's not a lot of point having a dispute because we've got no capacity to pay, and we think that it would be better for each party to bear their own costs. But if you don't want to do that, then we want you to waive the debt. So there are some alternatives, and obviously you've got to use a bit of common sense if you think that the circumstances are absolutely that liability to be denied. But I do think the vast majority of cases, our clients are probably going to be liable.
Terrific, thank you. I've also had a question come through, Dennis and Rose. I would like the presenters to perhaps explain where, if at all, motor vehicle repairers, panel beaters, mechanics might be referenced in these kind of disputes, and if they have any rights or responsibilities in this context, or particularly in relation to the things that kind of fall out of the code.
Okay, so if I'm assuming there you're acting for a client who's put in a claim for repairs to a motor vehicle and they're not happy with the repair quality. Firstly, under the code, if the insurer has actually authorised and appointed that repairer to carry out the work, they must guarantee the quality of the repairs for the life of the insured property. If there are any complaints about the quality of the work or the timeliness of the work, the insurer must deal with those complaints through its internal complaints process. So it is something that your client can complain about.
But can I add that about 10% of claims, I understand, are now being dealt with by what I would describe as carnapping, where a repairer grabs the vehicle through the tow truck and persuades a client not to make a claim. If you can get a client early on, a lot of insurers will actually accept a late claim, particularly if it comes through a legal centre. And it's also worth, and I might send this to you, James, and you can send it around. A lawyer in Melbourne has just been convicted by the Legal Services Commissioner of acting without instructions by issuing a claim in the client's name without ever seeking instructions. And the the lawyer was fined $20,000, made pay $8,000 costs, and required to do half a dozen ethics courses relating to that area of work. So there are a growing number of people who are actually having a problem where, unfortunately, the problem isn't with the insurer, it's with a repairer who's grabbed the vehicle, and that is something that we might need to turn our minds to in the future.
Terrific. A reminder to people who have tuned in, a couple more minutes for questions, so you can type them into the questions box or raise your hand by pressing the button that looks like a hand on your control panel. Now, can I ask about catastrophes? There was a reference to the parts of the code that apply to that. That requires the Insurance Council to declare a catastrophe, just as a matter of practice. Does that happen often?
Yes, it does. There's a difference between an extraordinary catastrophe and a catastrophe, but the Insurance Council declares a catastrophe, and that means that that event is actually allocated a catastrophe number. So from the perspective of your clients, it's important to know whether the damage that they've sustained is due to a catastrophe, because if that's the case, then there are additional protections for consumers who have claims settled, claims that arise out of those catastrophes. So extraordinary catastrophes are a lot rarer, thank goodness. But yes, so, the hailstorms, the recent hailstorms that have been around, there's been, what else has there been, Dennis, lately? There's been quite a few catastrophes declared already this year.
It's mainly flood, fire, can be hail. We've clearly had we must be getting close to some earthquakes coming up.
If you need to know for the purposes of a client that you're representing, my suggestion is that you go to the Insurance Council's website, and they actually have a page there that deals with catastrophes, and you'll be able to look for any media releases or any news and updates about what's happening about any recent catastrophes that have occurred.
Thank you. Another really good question's come through. We've had a few clients where liability was not an issue, but the insurer refused to pay out a claim until the client agreed to pay the excess, which the client couldn't afford. Is there a similar letter, or have you used similar letters requesting a waiver, and is that an appropriate response in that kind of situation?
Well, the financial hardship standards now apply to insureds in that position. So if the claim was lodged on or after 1 July, then if they are in that situation, that's probably the most common example that you'll come across is someone who can't pay an excess. They can request financial hardship assistance, and so they have access to the financial hardship standards under the code. Now, Dennis, was there a letter though?
Yeah, so there are two things. So someone in that situation should be referred to internal dispute resolution immediately, with the comment that it's a breach of the code and they want to have a financial hardship applied. There's a motor vehicle manual, I haven't looked at it for a little while, on the Footscray, which is part of the Western Community Legal Centre. So Footscray Legal Centre website has a letter that specifically applies to an excess. And the reason is there's also a New South Wales Court of Appeal decision which says that you can't refuse to process a claim on the basis of non-payment of an excess. Now, I think the code's much easier. So my proposition would be you have a look at the code, you find the one that says that you're claiming under financial hardship, and as soon as it goes to IDR, I believe that'll be solved. It's a sort of hangover from the past that it still happens. Now, the industry says that it's trying to stop it, but I think that I still hear cases from time to time. So there is a letter, if you go to the Footscray Community Legal Centre website, and it's a motor vehicle accident manual by Ali Yildiz. But I think the easier way is to simply ring, get the contact with internal dispute resolution and say, we want to apply for urgent financial hardship to deal with the fact. Now, there are just so you know, there are two ways the insurer can deal with that situation. One is they can say, well, we'll make a time payment arrangement for the insured to pay the excess, say, I don't know, over 3 or 6 or whatever months or whatever it is. but they can also say that we will pay out the claim less the excess. Now, the only problem is if the vehicle's with a repairer and the repairs cost $7,000, and there's a $1,500 excess, if they only pay $5,500, the vehicle may not be released if there's no payment. But for instance, a third-party claim where it's actually the other side pursuing, then that just leaves the other party, with a shortfall. So the IDR is probably the quickest solution.
Terrific, thank you. It looks as though that's all the questions we've got from our audience at this stage. I might just give people another few seconds to punch something in or raise their hand if they want to. Gone. Guys, can I thank you for giving up your Friday afternoon to deliver what's been a really informative and incredibly practical webinar. So thank you to, there's a question that's come through about what is the manual called. Again, Dennis, I think it was the Motor Vehicle Accident Manual. We might distribute a copy by email those people who have registered.
Yeah, and look, it's a little dated, but it's basically pretty right. The only warning I'll give is the letters in that haven't been updated for the new code that came in on the 1st of July, but the letter on the excess is about the Supreme Court case. So feel free, and you may actually find the manual covers all sorts of other sort of interesting things that can happen to your clients.
Terrific. Once again, Dennis and Rose, thanks very much for that presentation. On behalf of people sitting in front of computer screens across Australia who are cheering wildly, thanks very much. Can I thank everyone who participated in this webinar and has participated in our other webinars. Hope you found this as useful as I did. Have a great weekend, and we look forward to speaking to you all soon. Thanks.
Thank you.
Thanks, James.